to you by CTC Legal Media in collaboration with Tradespace. I'm Elizabeth Jordan, the Editor-in-Chief of the Patent Lawyer magazine and the Trademark Lawyer magazine. Today, 4 fantastic experts will be discussing reserving freedom to operate in the era of patent everything. Before we start, a note for our audience. There will be a Q&A session at the end of this discussion, so if you have a question, please type it into the questions panel, which you'll find on the right of your screen. You can submit questions at any point during the discussion, and we'll endeavour to get through as many of them as possible at the end. This session will also be available as a downloadable recording, accessible via the Patent Lawyer magazine website. We'd like to stress that the opinions expressed by our panelists today are their own and not those of their employers. So, without further ado, let's meet the panelists, starting with Elizabeth.
Hi, everyone. I'm also Elizabeth. Thank you, Elizabeth. I work for Everpure, formerly known as Pure Storage, and I'm as the Chief IP Counsel there. So really mostly focused on the patent portfolio, which is really what we're here to talk about today, but of course also other areas of IP. So very happy to be here and to chat more with the other esteemed panelists about strategies as the world is always changing.
I'll go next. Hi, everyone. Hi, everyone. My name is Keith Jurek. I'm Assistant General Counsel for IP at Grail. We're a cancer screening company. My remit lands somewhere between the software and the life sciences arts. So that's going to come up in some of the discussion, I believe. But I'm looking forward to the conversation today, and we can talk, looking forward to talking specifically about shifting from a more reactive approach to a more proactive approach, and how maybe that might actually be able to save us all money.
Fantastic, thanks, Keith. And Kavita?
Everyone, welcome. I'm Kavita. I wrote my first patent application in 1999, so I've been in the space for a while, but the last 10 plus years, I have become a generalist. So I'm excited to be on this panel to kind of offer a more generalist point of view. Marcia?
Hi, everyone. Apologies for my voice. I have a little bit of a cold, but really excited to be here. I'm VP of AI Legal and Customer Success at Tradespace. I made a shift in my career, having spent a lot of time in IP at law firms and companies like HP, a deep tech startup, and Applied Materials, to now be in the world of AI, where I am helping shape the future of IP by building helping build AI IP development and management platform. And my perspective will be that of somebody that has worked in IP in companies, law firms, and now seeing the shift on the AI side.
Fantastic, thanks everyone. So we're going to kick off this session with a couple of polls for our audience. So if you're an audience member, please select the answer that you agree with for each of these questions. And the first question is, how would you describe your current FTO/IP risk practice? It looks like a tight race at the moment. Okay, we're going to end that one there. And it looks like there's a tie between reactive only and routine product milestones. What do you guys think of that?
I think that makes sense. I think we definitely see that. I see that in my own practice, that of course there's times when you try to be proactive enough to at least do these analyses at the product milestone stage. I think companies certainly of a certain size tend to have a procedure that puts that in place. But there's of course always the necessity to do things when you have to for some sort of reactive purpose. So I think everybody is going to have a little bit of that.
Yeah, I'd like to say that I think this webinar is, if you're in the no formal practice or in the reactive only or even the routine FTO stage, like this webinar is your permission to think about the topic and think about what, is that the right strategy for your company at this stage, at this time, in light of what we're going to talk about, all the advancements in AI.
Okay, so let's move next to the next poll. We've got over the last 18 months, competitive filings in your core technology area have decreased, they're flat, increased, moderately, surged, or I don't know.
I admire the honesty of everyone who's answering that I don't know, and that's part of the problem. I think that admitting it is so difficult, but it also is probably true for more of us than we would like to admit, frankly. But.
Absolutely, that one seems to have drawn with flat. What do you guys think of that?
Yeah, that makes sense. That's it's not terribly surprising that the value of IP is not changing, and folks are finding a way to make it work. I think the I don't know is sort of the dark matter of this that I would imagine is going to be reflected in the slightly increased, but the sort of the absence of the decreasing filings I think says a lot.
I think the stats actually prove otherwise. In preparation for this call, I was researching what the stats are, and the number of patent applications like worldwide have gone up dramatically in the last 2 years, including, and one of the attributing factors was that now anybody can write a quick and dirty patent application using AI. So that was a contributing factor. But in Australia, it was like double the patent applications in the last 2 years. And in US also numbers have gone up.
Yeah, that's more in line with what I would expect. So I'm curious to see if the people that answer flat are in, specific technology areas where they haven't seen that impact yet. But eventually, I think it will come.
And the last poll today, biggest barrier to a more proactive practice? Is it your budget, headcount, tooling, exec buy-in, or speed of competitive filings?
As you're answering, I want to say that, again, this webinar is your permission to rethink this and go to your execs and ask for your budget and headcount and tools, at least tools. If your competitor has the best tools and they're armed with the MacBook and you're still on a typewriter, like that is not fair, right?
Absolutely. So that one's ended, and it seems budget is definitely ahead on that one. Is that a surprise?
Well, I think budget encompasses everything else, right? If you don't have budget, you don't have headcount, you can't buy tools, those pieces all kind of go together, and the budget is a more a larger category for what the things fall under that makes you not be as proactive as of course you would love to be in an absolutely ideal world.
Yeah, and I'm hopeful that some of the discussion we'll have today will shift the thinking, like Kavita said, take permission from this to look at other approaches where, the traditional FTO approach was going to be largely dependent on outside counsel and largely very expensive. And there might be other ways to mitigate that cost and still be pretty effective.
Absolutely. Well, thank you very much to the audience for your honesty, and I'll hand over to Marcia for the topics today.
Yeah, thanks, Elizabeth. I think this is great. I mean, we've already gotten a lot of insights from the audience, and I think it's clear, at least from our perspective as panelists, that the world of FTO has evolved quite a bit, right? It's no longer what it was even just 2 years ago, right? I think in the past, when we all heard of FTO, you thought of an exercise where you would get, a product was nearing launch, outside counsel was engaged, patents were reviewed, and then in the end, you would get this formal opinion of a counsel that would assess the risk, right? This model still exists. We saw in the first poll, right? People are still sometimes reactive and maybe still stuck to this past model. But I think to a large extent, I think a lot of the in-house teams today, especially when you look at, fast-moving environments in tech, right? You adopt a different strategy, more like an FTO light, more of a IP assessment risk, more like freedom of action, right? I mean, it's basically this overall idea, right? The business need to maintain strategic room to build, ship, scale, partner, right, without running into IP constraints. And I think the shift that we've seen is AI has fundamentally changed everything, has altered the economics on both sides of the equation. We see people still struggling with budget, and AI accelerating everything, right? Not only accelerating everything, but also dramatically reducing the cost and potential friction that you get when it comes to making decisions on filing, drafting patents, right? And Kavita, you pointed out the data that the filing has gone up. And I think like AI has accelerated the speed, of filing. And you're also able to file across potentially more incremental innovations, right? So I think the tools that you have today are very different from what they were a short time ago. So again, this is going to be our permission to, learn from this, from our shared perspectives to hopefully be able to get that budget that you need. And I think we're going to talk about what the current practice looks like and how it's changing and what are some of the smartest in-house teams are doing to tackle all these, shifts that we are seeing in the industry. So I think the first question that we have there is, what's actually changed, right? And what's the single biggest change in your FTO IP risk profile? And when did you first notice? And I don't know who wants to take that.
I can start. So what I'm hearing from my my peers is that in a lot of industries where patents are super critical to their product strategy, they're seeing that their competitors are looking at each other's patents and figuring out what the white space is where there aren't any patents and trying to put some blocking patents there. So that's sort of a new trend that some peers have seen in their industries. And it's easier to do now with the AI tools that help with FTOs and landscape studies.
Yeah, for sure. I just want to add on a little bit to that. I think Kavita's absolutely right. With the tools that are now potentially available, you can look for white space and you can look for areas that could be valuable to your company, and you can be proactively filing in those spaces. Certainly, my company is mostly going to focus software, focus in our patenting strategy. We do sell actual physical products, but and we have patents that are also in the more traditional sort of mechanical spaces as well, but in especially software, and Marcia touched on this a little bit, this concept of not just freedom to operate, but freedom of action is a term that is often tossed around in the software space, which is really like, hey, it's very hard just because of the way that people write software patents. There are a lot of overlapping ways to describe things. And so it's very possible for there to be quite a few patents in a space that that all overlap each other and are owned by various competitors. And so from that perspective, it's a little bit of a Cold War situation, or we have so many patents and you have so many patents, and let's agree to not shoot them at each other. And I think understanding your technology space and whether you are really in the kind of area where freedom of action makes sense might make it true that the number of official freedom to operate, letters, analyses that are done might only come up in very specific instances. That's certainly what I've seen in my practice. We still do them, but not all the time.
To continue the Cold War analogy there, I think the biggest shift that we've seen is changing from a point in time assessment that you're, every year, every 6 months, where you're then taking stock of what the landscape looks like around you, instead shifting to a more continuous stance where you are getting micro updates as you're going. So setting up active monitoring so that when a certain assigner has a new application published, you're reviewing it right then, and then you're deciding, is this in the subject matter that I'm interested in, or is this in subject matter that I can kind of put on the back burner? And what that lets you do is it lets you kind of stay more educated, so that when leadership does ask, hey, what's our space? You're not scrambling to come up with an answer, but it also lets you be more, lets you allocate, if you want to be more of take a more aggressive stance towards filing in white space, it lets you sort of decide, are there certain technologies or competitors that I want to target in a way that is informed by what they're doing. So it's sort of the it's allowing you to take a more active sonar approach as opposed to one where you're just only checking in on a infrequent basis.
That's a great point, Keith. And I don't know. I think everybody noticed, right, in one of the polls that continuous monitoring is one category that people are not doing as much. And I think, if anything, we hope that you take away from this is that that's what you should be doing, and that's what I think. What, at least from my perspective, that I've seen the change happens is, it stopped being that periodic, more formal legal exercise into this continuous monitoring, continuous assessing your landscape, and especially now, right, that technology has become complex and very interconnected. So, you can't just look at things, in isolation. Products are layered systems and complex systems. And, you have to take into account all of the different aspects of it. And, the patent landscape has expanded, right? And risk is no longer in just one domain or in one thing in isolation, right? It's all interconnected. And I think with that, it creates a lot of noise, right? How do you sort the noise from the actual signals, right? And how do you manage your budget to really figure out, okay, there's all this noise out there. How am I going to figure out which filing matters, right? And how am I going to understand which ones are speculative, which ones are duplicative, which ones are, drafted at a level that may never really be commercially meaningful, right? So I think that this continuous monitoring allows you to learn all the time, how to get better at sifting, at understanding the signals and understanding how to, ignore some of the noise, right? And I think ultimately that changes the model, right? You can't just do these periodic exercises, right? It's a continuous IP risk management approach. And because the landscape is certainly not static, and it's not like a stable landscape. I mean, it evolves, gets more complex, gets more dense. So I think it's all, this challenge, right? And it's no longer like, can we find, the relevant patents here? Is like, can I develop this capability to get better at distinguishing, signal from noise across this very, very complex, fast moving landscape, with products themselves becoming interconnected, right? And more difficult to separate, right? So, and I think that begs the question, when we talk about freedom to operate, I mean, do you even use this term in your organizations? I mean, I think, Elizabeth, you talked about freedom of action, right? How about life sciences, Keith? Is that, when you do your continuous monitoring, I mean, how do you characterize that internally when you are trying to justify to your leadership that you need that budget to potentially engage another outside counsel to do this extra analysis?
Yeah, we have the benefit of our leadership is really they're invested in freedom to operate and freedom to launch the product, to protect the launch, because so much of our leadership they're highly sensitized to the fact that it's no surprise Grail is a single product company, and protecting that product is tantamount. And that's true of a lot of life sciences companies, where you've got these like massive blockbuster, drugs or tests or whatever it may be. So thankfully, we don't have to educate leadership on the importance of freedom to operate in that space, which is really nice. Instead, it ends up being framed as more of a component of an enterprise risk management platform, where our compliance team leads ERM exercises on a regular basis. And there's a whole host of categories that are considered there. Security, patient interactions, privacy concerns. It's a really, really long, physical and cybersecurity, really long list of concerns. And FTO is one of those components. And so we are sort of being pushed to have a continuous approach by having this continuous assessment of risk management. But at the same time, it makes it much easier for us to justify our budget by pointing towards enterprise-wide goals and making a very easy direct chain. And I wanted to add, Marcia, the good news is that yes, it's really challenging to move to a continuous approach, but that it's not just a human-only exercise at this point. And this is probably the biggest change that I've seen, even in the last 6 months, is that there are a wealth of vendors and tools and software suites and approaches that are changing from a very simple keyword-based search to keywords, classifications, syntactic understanding that lets you build a holistic picture of what your search is doing with significantly fewer human assets required if you decide to take that approach. We take a very hands-on approach where we're all personally reviewing a lot of applications as they're being filed and patents as they're being granted. But if you're, a one-person IP department, or if you're a half a person IP department, there are tools and there are vendors out there that are going to be able to help you develop a comprehensive picture. And that's something that was really enabled by this boom in AI vendors.
Yeah, just want to make a point about the vendors. I think it's important to note that, and I wonder what the panelists think if you've tried out other, and we're not going to talk about specific tools on this call, but my impression is that sort of the ChatGPT and Claudes of the world are not good enough for this job. Like, you do need to go out there and get like specialized tools, which is, of course, then that creates budgetary requirements. But just wondering what your thoughts are on that. Unfortunately, these tools are not good. The enterprise tools that you might already have are not good enough for purpose here.
No, I absolutely agree with that. Actually, specifically in the FTO space, that's something we were looking at. When you get an opinion of counsel or something, right? There's definitely the possibility that things change over time, and you want to make sure that you're keeping up to date on that analysis. You don't just put that opinion on a shelf and leave it there in case you ever need it later. And so that's something my company's been actively looking at, is how do we get a tool specifically designed in this space that could help make sure that we are refreshing, as Keith sort of said, on a essentially constant basis, so that we are comfortable with the fact that any opinion we received in the past is still true, right? So, like, for instance, if we're looking at a particular case and we had been told by counsel that the case was invalid, well, that might be true, but what if there's and maybe that doesn't change because it's prior art, but what if there's a child of that patent, right? What are those claims and what's the analysis there? And that's something that you can be monitoring. And similarly, if you receive the opinion of counsel specifically on why you don't infringe, you need to be keeping up specifically also with your, changes within your own company. But some analysis of like what else is going on in the market, what else is changing over time, and are you keeping up with the things in your industry? And I think you're right, Kavita, like this is not something that you can get necessarily good information from, say, like Gemini, which is one of the tools my company has given to everyone. But there are really good tools out there that I've analyzed and said, oh yeah, like this could really help us keep up to date all the time.
Yeah, let me just cite a study that I found, which is a March 2026 controlled study found that purpose-built patent AI identified 40 plus, in a particular study, 40 plus active US patents with granular FTO risk assessments, while ChatGPT found 7, several were fabricated, Claude found 12, and Copilot found 4. So just food for thought for those who are thinking that you could get away with general purpose AI tools for this.
And what's really funny, though, is that a lot of those specialized vendors, they're building on top of, right? They're not using wildly different techniques. It's just you need the specialization, the expertise, the fine tuning that you get when you have one of those specialists.
And the data, right? They have access. Yeah.
Yeah. I mean, this is great. I mean, I think that, I'm at Tradespace, right? So we are specialized IP tools. So, but I think the webinar, we're here to, to share perspective with the kids. So I'm going to, shift away from the tool. And I just want to ask, when you're doing this assessments, right? The trigger for this, I mean, does it come from you, from your department? Do you have product leaders and R&D leaders in your organizations, or maybe, parallel to your IP function, maybe somebody in compliance, litigation? I mean, who is kind of like driving the continuous monitoring? I mean, is it you? Is it, a joint effort? And when you're having these discussions, I mean, is it easier when you have somebody else, to align with, to push for potentially more budget and so forth?
In my experience, it's been the IP team, right? That it's the IP team that really is focused on what patents exist, that your company has, what patents your competitors have, what the space looks like. And I think it's often true that, I mean, you are the expert, right? So of course, if Keith, I guess, only has the one product, right? So everyone's focused on making sure that they're focused on that single product. But in a company that has multiple products, every product leader has their own opinion about patents, and some people are more interested than others, but that doesn't mean that you shouldn't be holistically protecting the entire lineup of your company. And I do think that typically falls to the patent department to make sure that that's being done effectively, and then that they're communicating effectively to get buy-in. But I have rarely seen it driven externally. The only time I think this is an industry. Go ahead.
It's an industry specific thing, Elizabeth. I wonder, like, it depends on the industry. When I was at Rambus, there's no need, like this is the product, right? So there was no need to sell the leadership on it. But, same for Keith, right? His business demands it. The product leaders are very attuned to the patent landscape. It just depends on your business, the stage they're in. And so as the IP lawyer, the patent lawyer for the company, you might need to create to sell why the company needs to do this.
Yeah, I think it's great if you happen to be in a company that everyone's pushing for it, right? But if you're in a company that doesn't, like, I think you need to take it upon yourself as the IP attorney to make sure it's happening, because it might not be happening if you don't push for it.
And it was by no means, just this environment that we exist where people are highly sensitized to IP issues just existed. It was through education. It was through really strong relationship building. We have really good relationships with technical and research leadership to make sure that we understand all the nuance, all the little changes that are happening, all the future product designs that are happening. So it's not that we're getting involved as early as we can in order to stay as far ahead of the curve as possible, so that we can help inform. If you're considering this change in product or this next strategy in something, that we're aware of the very fine technical details, so that we can update our monitoring and our searching to help inform. Potentially, let's steer the product towards this way, or let's steer this other project towards this other thing. But it really does require a lot of relationship building and a lot of very tight interactions where a lot of the engineering and research team, like, they know me by face, where when they see me in the hallway, they can stop me. And I think that's to the credit of, or that's a large reason why we're successful. And as far as what the triggers are for when we update our terms or update what our search strategy looks like, that is actually coming from product leadership of when we know, someone had this crazy idea and we want to check it out, or when we know, hey, we're locking this version of the product or this component of the product down, we're locking it down. Let's finalize it and let's make sure that we get our terms updated on it. But IP, of course, owns the ultimate assessment. We use technical feedback to inform it, but IP owns it and manages it.
If you reminded me of a point, which is, a lot of the work that you're describing, like Elizabeth and I used to be at the same firm, like we used to do these landscape studies for clients, right? Like a lot of the work you're describing was done by outside counsel before, right? And now it's been brought in-house, and hopefully with tools, so you're not doing it manually. But do you want to speak more on that? You were at big firm before, like what do you think of that?
Of the kind of the in-housing of it all?
Yes.
I think it's appropriate, frankly. I think that it's a challenge and it's a big workload addition, but it's a matter of prioritization, because I also do these assessments as outside counsel. That's how I got the practice in it. And it was always so frustrating to have, here's our list of assets that we want to discuss, and then we need to rely on in-house counsel to find the technical experts, because in-house counsel, they didn't have the firsthand knowledge of either side of that coin, right? Of what the patents actually look like in the space and what the technical components actually look like. They were a connecting thread, and that's how they were able to stay informed. But I could sense the frustration from in-house counsel because they weren't able to answer questions directly. So I think in a lot of ways, this shift to let's remove outside counsel where we can and do this directly by allowing for in-house counsel to have a direct relationship with the patents and with the technical components. I think for me, as someone who works in technology and finds it very fascinating, it's more engaging for me and it keeps me entertained.